Hello, everyone. Today's case is Department of State versus Muñoz. This is a case about living with your spouse compared to the fundamental right to marry. So, respondent Sandra Muñoz is an American citizen. In 2010, she married Luis Asensio Cordero, a citizen of El Salvador. The couple eventually sought to obtain an immigrant visa for Asensio Cordero so that they could live together in the United States. Munoz filed a petition with the United States Citizenship and Immigration Services to have Asensio Cordero classified as an immediate relative. USCIS granted Munoz's petition, and Asensio Cordero traveled to the consulate in San Salvador to apply for a visa. After conducting several interviews with Asensio Cordero, a consular officer denied his application, citing subsection 1182A, subsection 3, subsection A2, a provision that renders inadmissible a non-citizen whom the officer knows or has reasonable ground to believe seeks to enter the United States to engage solely, principally, or incidentally in certain specified offenses or any other unlawful activity. Asensio Cordero guessed that he was denied a visa based on a finding that he was a member of MS-13, a transnational criminal gang. So he disavowed any gang membership, and he and Munoz pressed the consulate to reconsider the officer's finding. When the consulate refused, they appealed to the Department of State, which agreed with the consulate's determination. Asensio Cordero and Munoz then sued the Department of State and others, collectively the State Department, claiming that it had abridged Munoz's constitutional liberty interest in her husband's visa application by failing to give a sufficient reason why Asensio Cordero is inadmissible under the unlawful activity bar. The district court granted summary judgment of the State Department to the State Department, but the Ninth Circuit vacated the judgment, holding that Munoz had a constitutionally protected liberty interest in her husband's visa application. Because of that interest, the court said, the Due Process Clause required the State Department to give Munoz a reason for denying her husband's visa. The court further held that by declining to give Munoz more information earlier in the process, the State Department had forfeited its entitlement to insulate its decision from judicial review under the doctrine of consular non-reviewability. Held. A citizen does not have a fundamental liberty interest in her non-citizen spouse being admitted to the country. Under the doctrine of consular non-reviewability, an executive officer's decision to admit or to exclude an alien is final and conclusive, and not subject to judicial review in federal court. This court has assumed a narrow exception in cases when the denial of a visa allegedly burdens the constitutional rights of a U.S. citizen. In that event, the court has considered whether the executive official gave a facially legitimate and bona fide reason for denying the visa. Asensio Cordero cannot invoke the exception himself, thus Munoz must assert that the denial of her husband's visa violated her constitutional rights, thereby enabling judicial review. She argues that the State Department abridged her fundamental right to live with her spouse in her country of citizenship without affording her due process. Among other things, the Due Process Clause provides heightened protection against government interference with certain fundamental rights and liberty interests. When a fundamental right is at stake, the government can act only by narrowly tailored means that serve a compelling state interest. To identify an unenumerated right, the court follows the two-step inquiry in Glucksberg. That inquiry first insists on a careful description of the asserted fundamental liberty interest. Second, the inquiry stresses that the Due Process Clause especially protects only those fundamental rights and liberties which are objectively deeply rooted in this nation's history and tradition. Here, Munoz invokes the fundamental right to marriage, but she actually claims something more distinct, the right to reside with her non-citizen spouse in the United States. That involves more than marriage and more than spousal cohabitation. It includes the right to have her non-citizen husband enter and remain in the United States. As Munoz asserts it, she claims a marital right sufficiently important that it cannot be unduly burdened without procedural due process as to an inadmissibility finding that would block her from residing with her spouse in her country of citizenship. So described, the asserted right is fundamental enough to be implicit in liberty, but unlike the other implied fundamental rights, its deprivation does not trigger strict scrutiny. Because Muñoz cannot clear the second step of Glucksberg, the court need not decide whether such a category of implied rights protected by the Due Process Clause exists. Glucksberg requires a demonstration that the asserted right be deeply rooted in this nation's history and tradition. This nation's history and tradition recognizes the government's sovereign authority to set the terms governing the admission and exclusion of non-citizens, and Muñoz points to no subsidiary tradition that curbs this authority in the case of non-citizen spouses. From this nation's beginnings, the admission of non-citizens into the country was characterized as of favor and not of right. And when Congress began to restrict immigration in the late 19th century, the laws it enacted provided no exceptions for citizen spouses. And while Congress has, on occasion, extended special immigration treatment to marriage, it has never made spousal immigration as a matter of right. This court has not interfered with such policy choices, despite their interference with the spousal relationship. Thus, in UX ex rel Novi Shaughnessy, the court reaffirmed in the case of a non-citizen spouse who was denied admission for confidential security reasons the long-standing principle that the United States can, as a matter of public policy, forbid aliens or classes of aliens from coming within its borders, and no limits can be put by the courts upon that power. Muñoz claimed that a procedural due process right in someone else's legal proceeding would have unsettling collateral consequences. Her position would usher in a new strain of constitutional law, one that prevents the government from taking actions that indirectly or incidentally burden a citizen's legal rights. To be sure, Muñoz has suffered harm from the denial of Asensio Cordero's visa application, but that harm does not give her a constitutional right to participate in his consular proceeding. Reversed and remanded. Justice Barrett delivered the opinion of the court, in which Roberts, Thomas, Alito, and Kavanaugh joined. Gorsuch filed an opinion concurring in judgment. Sotomayor filed a dissenting opinion, in which Kagan and Jackson dissented, joined. Justice Barrett delivered the opinion of the court. Luis Asensio Cordero seeks to enter the United States to live with Sandra Muñoz, his wife. To obtain the necessary visa, he submitted an application at the United States Consulate in San Salvador. A consular officer denied his application, however, after finding that Asensio Cordero is affiliated with MS-13, a transnational criminal gang. Because of national security concerns, the consular officer did not disclose the basis for his decision. And because Asensio Cordero, as a non-citizen, has no constitutional right to enter the United States, he cannot elicit that information or challenge the denial of his visa. Muñoz, on the other hand, is a citizen, and she filed her own challenge to the consular officer's decision. She reasons as follows. The right to live with her non-citizen spouse in the United States is implicit in the liberty protected by the Fifth Amendment. The denial of her husband's visa deprived her of this interest, thereby triggering her right to due process. The consular officer violated her right to due process by declining to disclose the basis for finding Asensio Cordero inadmissible. And this, in turn, enables judicial review, even though visa denials are ordinarily unreviewable by courts. Muñoz's argument fails at the threshold. Her argument is built on the premise that the right to bring her non-citizen spouse to the United States is an unenumerated constitutional right. To establish this premise, she must show that the asserted right is deeply rooted in this nation's history and tradition. She cannot make that showing. In fact, Congress's long-standing regulation of spousal immigration, including through bars on admissibility, cuts the other way. To be admitted to the United States, a non-citizen typically needs a visa. As a general matter, Congress sets the terms for entry, and the Department of State implements those requirements at United States embassies and consulates in foreign countries. Congress has streamlined the visa process for non-citizens with immediate relatives in the United States. The citizen relative must first file a petition with U.S. Citizenship and Immigration Services, USCIS, an agency housed within the Department of Homeland Security, to have the non-citizen classified as an immediate relative. If USCIS approves the petition, then the non-citizen may apply for a visa. As part of this process, the non-citizen submits written materials and interviews with a consular officer abroad. Ordinarily, a consular officer who denies a visa application because the officer determines the alien to be inadmissible must provide the alien with a timely written notice that A. states the determination and B. the specific provision or provisions of law under which the alien is inadmissible. The statute requires no explanation, however, to any alien inadmissible on certain grounds related to crime and national security. This case involves a non-citizen to whom this statutory exception applies. Sandra Muñoz, an American citizen, married Luis Asensio Cordero, a Salvadoran citizen, in 2010. Several years later, the couple began taking steps to obtain an immigrant visa for Asensio Cordero. Muñoz filed a petition to classify her husband as an immediate relative, which USCIS granted. Because Asensio Cordero has entered the United States unlawfully, he was required to return to El Salvador and submit his visa application at a consulate there. He met with a consular officer in San Salvador and underwent several interviews. In December 2015, the officer denied Asensio Cordero's application, citing 8 U.S.C. subsection 1182, A subsection 3A2. That provision renders inadmissible a non-citizen whom the officer knows or has reasonable grounds to believe seeks to enter the United States to engage solely, principally, or incidentally in certain specified offenses or any other unlawful activity. The officer provided no additional details, but given the reason for the visa denial, even the statutory citation was more information that Asensio Cordero was entitled to receive. Asensio Cordero guessed, as it turns out accurately, that he was denied a visa based on a finding that he was a member of MS-13, a transnational criminal gang. He also guessed, again accurately, that this finding was based at least in part on the conclusion that his tattoos signified gang membership. Asensio Cordero and Muñoz denied that Asensio Cordero was affiliated with MS-13 or any other gang, and they pressed the consulate to reconsider the officer's finding. When the consulate held firm, they appealed to the Department of State, submitting evidence that the tattoos were innocent. A department official informed Asensio Cordero and Muñoz that the department agreed with the consulate's determination. The next day, the consul in San Salvador notified them that Asensio Cordero's application had gone through multiple rounds of review, including by the consular officer, consular supervisors, the consul himself, the Bureau of Consular Affairs, and the State Department's Immigration Visa Unit, and none of these reviews had revealed any grounds to change the finding of inadmissibility. Asensio Cordero and Muñoz sued the Department of State, the Secretary of State, and the United States Consul in San Salvador. For simplicity's sake, we will refer to the defendants collectively as the State Department. They alleged, among other things, that the State Department had abridged Muñoz's constitutional liberty interest in her husband's visa application by failing to give a sufficient reason why Asensio Cordero is inadmissible under the unlawful activity bar. The district court agreed and ordered discovery. In a sworn declaration, an attorney advisor from the State Department explained that Asensio Cordero was deemed inadmissible because he belonged to MS-13. The finding was based on the in-person interview, a criminal review of Asensio Cordero, and a review of his tattoos. In addition to the affidavit, the State Department provided the district court with confidential law enforcement information, which it reviewed in camera, identifying Asensio Cordero as a member of MS-13. Satisfied, the district court granted summary judgment to the State Department. The Ninth Circuit vacated the judgment and remanded the case. Consistent with circuit precedent, it held that Muñoz, as a citizen, had a constitutionally protected liberty interest in her husband's visa application. Because of that interest, the Ninth Circuit said, the Due Process Clause required the State Department to give Muñoz a facially legitimate and bona fide reason for denying her husband's visa. The initial statutory citation did not qualify, and the later affidavit was untimely. Delay carried a serious consequence for the State Department. Visa denials are insulated from judicial review by the doctrine of consular non-reviewability, but the Ninth Circuit held that by declining to give Muñoz more information earlier in the process, the State Department had forfeited its entitlement to shield its visa decision from judicial review. The panel remanded for the district court to consider the merits of Muñoz's suit, which include a request for a declaration invalidating the finding that Asensio Cordero is inadmissible and an order demanding that the State Department re-adjudicate Asensio Cordero's application. The Ninth Circuit denied en banc review over the dissent of 10 judges, and we granted the State Department's petition for certiorari. For more than a century, this court has recognized that the admission and exclusion of foreign nationals is a fundamental sovereign attribute exercised by the government's political departments, largely immune from judicial control. Congress may delegate to executive officials the discretionary authority to admit non-citizens immune from judicial inquiry or interference. When it does so, the action of an executive officer to admit or to exclude an alien is final and conclusive. The judicial branch has no role to play unless expressly authorized by law. The Immigration and Nationality Act, the INA, does not authorize judicial review of a consular officer's denial of a visa. Thus, as a rule, the federal courts cannot review those decisions. This principle is known as the doctrine of consular non-reviewability. We have assumed that a narrow exception to this bar exists when the denial of a visa allegedly burdens the constitutional rights of a U.S. citizen. In that event, the court has considered whether the executive gave a facially legitimate and bona fide reason for denying the visa. If so, the inquiry is at an end. The court has disclaimed the authority to look behind the exercise of that discretion, much less to balance the reason given against the asserted constitutional right. Asensio Cordero cannot invoke the exception himself, because he has no constitutional right of entry to this country as a non-immigrant or otherwise. Thus, so far as Asensio Cordero is concerned, the doctrine of consular non-reviewability applies. Muñoz, however, is an American citizen, and she asserts that the denial of her husband's visa violated her constitutional rights, thereby enabling judicial review. Specifically, she argues that the State Department abridged her fundamental right to live with her spouse in her country of citizenship, and that it did so without affording her the fair procedure guaranteed by the Fifth Amendment. The Ninth Circuit is the only court of appeals to have embraced this asserted right. Every other circuit to consider the issue has rejected it. In Din, this court considered but did not resolve the question. A plurality concluded that a citizen does not have a fundamental right to bring her non-citizen spouse to the U.S. Two justices chose not to reach the issue, explaining that even if the right existed, the statutory citation provided by the executive qualified as a facially legitimate and bona fide reason. Since Din, the existence of the right has continued to divide the circuits. Today, we resolve the open question. Like the Din plurality, we hold that a citizen does not have a fundamental liberty interest in her non-citizen spouse being admitted to the country. The Due Process Clause of the Fifth Amendment requires the government to provide due process of law before it deprives someone of life, liberty, or property. Under our precedent, the clause promises more than fair process. It also provides heightened protection against government interference with certain fundamental rights and liberty interests. When a fundamental right is at stake, the government can act only by narrowly tailored means that serve a compelling state interest. Identifying unenumerated rights carries a serious risk of judicial overreach, so this court exercises the utmost care whenever we are asked to break new ground in this field. To that end, Glucksberg's two-step inquiry disciplines the substantive due process analysis. First, it insists on a careful description of the asserted fundamental liberty interest. Second, it stresses that the Due Process Clause specially protects only those fundamental rights and liberties which are, objectively, deeply rooted in this nation's history and tradition. We start with a careful description of the asserted fundamental liberty interest. Muñoz invokes the fundamental right of marriage, but the State Department does not deny that Muñoz, who is already married, has a fundamental right to marriage. Muñoz claims something distinct, the right to reside with her non-citizen spouse in the United States. That involves more than marriage and more than spousal cohabitation. It includes the right to have her non-citizen husband enter and remain in the United States. It is difficult to pin down the nature of the right Muñoz claims. The logic of her position suggests an entitlement to bring Asensio Cordero to the United States. How else could Muñoz enjoy the asserted right to live with her non-citizen husband in her country of citizenship? Yet Muñoz disclaims that characterization, insisting that she does not advance a substantive right to immigrate one's spouse. This concession is wise, because such a claim would ordinarily trigger strict scrutiny, and it would be remarkable to put the government to the most demanding test in constitutional law in the field of immigration, an area unsuited to rigorous judicial oversight. Though understandable, Muñoz's concession makes characterizing the asserted right a conceptually harder task. Here is her formulation. A marital right sufficiently important that it cannot be unduly burdened without procedural due process as to an inadmissibility finding that would block her from residing with her spouse in her country of citizenship. So described, the asserted right is neither fish nor fowl. It is fundamental enough to be implicit in liberty, but unlike other implied fundamental rights, its deprivation does not trigger strict scrutiny. This right would be in the category of 1, a substantive due process right that gets only procedural due process protection. We need not decide whether such a category exists because Muñoz cannot clear the second step of Glucksberg's test, demonstrating that the right to bring a non-citizen spouse to the United States is deeply rooted in this nation's history and tradition. On the contrary, the through line of history is recognition of the government's sovereign authority to set the terms of governing the admission and exclusion of non-citizens, and Muñoz points to no subsidiary tradition that curbs this authority in the case of non-citizen spouses. From the beginning, the admission of non-citizens into the country was characterized as of favor and not of right. Consistent with this view, the 1798 Act concerning aliens gave the President complete discretion to remove all such aliens as he shall judge dangerous to the peace and safety of the United States. The Act made no exception for spouses, or for that matter, other family members. The United States had relatively open borders until the late 19th century, but once Congress began to restrict immigration, it enacted a complicated web of regulations that erected serious impediments to a person's ability to bring a spouse into the United States. One of the first federal immigration statutes, the Immigration Act of 1882, required executive officials to examine non-citizens and deny permission to land to any convict, lunatic, idiot, or any person unable to take care of himself or herself without becoming a public charge. The act provided no exception for citizen spouses, and when Congress drafted a successor statute that expanded the grounds of inadmissibility, it again gave no special treatment to the marital relationship. There are other examples. The Page Act of 1875, which functioned as a restriction on Chinese female immigration, contained no exception for wives. Or consider the Emergency Quota Act of 1921, which capped the number of immigrants permitted to enter the country each year. Although the act gave preferential treatment to citizens' wives, once all the quota spots were filled for the year, the spouse was barred without exception. In 1924, Congress, showing favor to men rather than marriage, lifted the quotas for male citizens with non-citizen wives, but did not similarly clear the way for female citizens with non-citizen husbands. This gender disparity did not change until 1952. That is not to say that Congress has not extended special treatment to marriage. It has. For instance, the War Brides Act of 1945 provided that the non-citizen spouses of World War II veterans would be exempt from certain admissibility bars and documentary requirements. Closer to home, Asensio Cordero's visa application rested on his marriage to Muñoz, which made him eligible for immigrant status. But while Congress had made it easier for spouses to immigrate, it has never made spousal immigration a matter of right. On the contrary, qualifications and restrictions have long been the norm. Of particular relevance to Muñoz, Congress has not exempted spouses from inadmissibility restrictions like the INA's unlawful activity bar. Precursors to that bar have existed since the early 20th century. For example, the Immigration Act of 1917 provided for the exclusion of persons who have been convicted of or admit having committed a felony or other crime or misdemeanor involving moral turpitude. Consular officers applied this bar to spouses, and courts refused to review those visa denials, citing the doctrine of consular non-reviewability. United States ex rel. Na v. Shaughnessy is a striking example from this court. In Knopf, a United States citizen and World War II veteran found himself similarly situated to Muñoz. His non-citizen wife was denied admission for security reasons, based on information of a confidential nature, the disclosure of which would be prejudicial to the public interest. We held that the War Brides Act did not supersede the statute on which the Attorney General had relied. So, as all other aliens, petitioner had to stand the test of security. nor was she entitled to a hearing, because whatever the procedure authorized by Congress is, it is due process as far as an alien denied entry is concerned. The Attorney General's decision was final and conclusive, and he did not have to divulge the reason for it. Knopf thus reaffirmed the long-standing principle that the United States can, as a matter of public policy, forbid aliens or classes of aliens from coming within their borders, and no limits can be put by the courts upon that power. Congress's authority to formulate policies concerning the entry of non-citizens has become about as firmly embedded in the legislative and judicial tissues of our body politic as any aspect of our government, representing not merely a page of history, but a whole volume. The court's general reaffirmations of this principle have been legion. While families of putative immigrants certainly have an interest in their admission, it is a fallacy to leap from that premise to the conclusion that United States citizens have a fundamental right that can limit how Congress exercises the nation's sovereign power to admit or exclude foreigners. To be sure, Congress can use its authority over immigration to prioritize the unity of the immigrant family. It has frequently done just that, but the Constitution does not require this result. Moreover, Congress's generosity with respect to spousal immigration has always been subject to restrictions, including bars on admissibility. This is an area in which more than family unity is at play. Other issues, including national security and foreign policy, matter too. Thus, while Congress may show special solicitude to non-citizen spouses, such solicitude is a matter of legislative grace rather than fundamental right. Muñoz has pointed to no evidence suggesting otherwise. As the State Department observes, Muñoz's claim to a procedural due process right in someone else's legal proceeding would have unsettling collateral consequences. Consider where her logic leads. Could a wife challenge her husband's assignment to a remote prison or to an overseas military deployment, even though prisoners and service members themselves cannot bring such challenges? Could a citizen assert procedural rights in the removal proceeding of her spouse? Muñoz's position would usher in a new strain of constitutional law, for the Constitution does not ordinarily prevent the government from taking actions that indirectly or incidentally burden a citizen's legal rights. Our decision in O'Bannon is illustrative. There, a group of nursing home residents alleged that the government had violated their liberty interests when it decertified their nursing home without providing them a hearing. We acknowledged that the residents would suffer harm from the government's decision, but we held that absent a direct restraint on their liberty, the decision did not implicate their due process rights. The decertification decision imposed only an indirect harm. We explained that the residents were akin to members of a family who have been dependent on an errant father. Although they may suffer serious trauma if he is deprived of his liberty or property as a consequence of criminal proceedings, such family members surely have no constitutional right to participate in his trial or sentencing procedures. The same principle governs here. Muñoz has suffered harm from the denial of Asensio Cordero's visa application, but that harm does not give her a constitutional right to participate in his consular process. Lest there be any doubt, Mandel does not hold that citizens have procedural due process rights in the visa proceedings of others. The Ninth Circuit seems to have read Mandel that way, but that is a misreading. In Mandel, the Attorney General refused to waive inadmissibility and granted Ernest Mandel, a self-described revolutionary Marxist, a temporary visa to attend academic conferences in the United States. A group of professors sued on the ground that the executive's discretion to grant a waiver was limited by their First Amendment right to hear Mandel speak. They insisted that the First Amendment claim should prevail, at least where no justification is advanced for denial of a waiver. In response, the Attorney General asserted that Congress has delegated the waiver decision to the executive in its sole and unfettered discretion, and any reason or no reason may be given. But because the Attorney General did inform Mandel's counsel of the reason for refusing him a waiver, the court chose not to resolve this statutory argument. Instead, it said that so long as the executive gives a facially legitimate and bona fide reason for denying a waiver under subsection 212A28 of the INA, the statutory provision at issue, the courts will neither look behind the exercise of that discretion nor test it by balancing its justification against the First Amendment interests of those who seek personal communication with the applicant. The court expressly declined to address whether a constitutional challenge would be available for attacking an exercise of discretion for which no justification whatsoever is advanced. Thus, the facially legitimate and bona fide reason in Mandel was the justification for avoiding a difficult question of statutory interpretation. It had nothing to do with procedural due process. Indeed, a procedural due process claim was not even before the court. The professors argued that the denial of Mandel's visa directly deprived them of their First Amendment rights, not that their First Amendment rights entitle them to procedural protections in Mandel's visa application process. To make an argument logically analogous to that of the professors, Muñoz would have to claim that the denial of Asensio Cordero's visa violated her substantive due process right to bring her non-citizen spouse to the United States, thereby triggering the State Department's obligation to demonstrate why denying him the visa is the least restrictive means of serving the government's interest in national security. But, as we have explained, Muñoz has disavowed that argument, which cannot succeed in any event because the asserted right is not a long-standing and deeply rooted tradition in this country. The bottom line is that procedural due process is an odd vehicle for Muñoz's argument, and Mandel does not support it. Whatever else it may stand for, Mandel does not hold that a citizen's independent constitutional right, say a free speech claim, gives that citizen a procedural due process right to a facially legitimate and bona fide reason for why someone else's visa was denied, and Muñoz is not constitutionally entitled to one here. The judgment of the Ninth Circuit is reversed, and the case is remanded for further proceeding consistent with this opinion. It is so ordered. Justice Gorsuch concurring in the judgment. A consular officer denied Sandra Muñoz's husband a visa to come to and live lawfully in the United States. In doing so, the officers simply cited 8 U.S.C. subsection 1182A 3A2, a provision of the Immigration and Nationality Act that makes inadmissible any person a consular officer has reasonable grounds to believe seeks to enter the United States to engage in any other unlawful activity. Eventually, Ms. Muñoz sued for further explanation of that decision. The government, she claimed, needed to identify for her not just the statute on which it based its decision, but also the discrete factual predicates on which it relied. Over the course of this litigation, the United States has given Ms. Muñoz what she requested. As the Ninth Circuit recognized, the United States has now revealed the factual basis for its decision to deny her husband a visa. In this court, too, the government has assured Ms. Muñoz that she has a chance to use and respond to that information. She can again seek her husband's admission to this country, the government says, and this time she will be armed with an understanding of why the government denied the last application. Those developments should end this case. With no more information to uncover and no bar to trying for admission again, nothing is left for a court to address through this litigation. In particular, the constitutional questions presented by the government no longer have any practical relevance here. Whether or not Ms. Muñoz had a constitutional right to the information she wanted, the government gave it to her. I therefore would reverse the Ninth Circuit's decision without reaching the government's constitutional arguments. At the same time, I do not cast aspersions on the motives of my colleagues who do reach the government's arguments. They may see the case differently than I do, but their decision and rationales are essentially those the Solicitor General and the Department of State urge this court to adopt. Justice Sotomayor, with whom Justice Kagan and Justice Jackson joined dissenting, the right to marry is fundamental as a matter of history and tradition. After U.S. citizen Sandra Muñoz and her Salvadoran husband spent 5 years of married life in the United States, the government told her that he could no longer re-enter the country. If she wanted to live together with him and their child again, she would have to move to El Salvador. The reason? A consular officer's bare assertion that her husband, who has no criminal record in the United States or El Salvador, planned to engage in unlawful activity. Muñoz argues that the government, having burdened her fundamental right to marriage, owes her one thing: the factual basis for excluding her husband. The majority could have resolved this case on narrow grounds under long-standing precedent. This court has already recognized that excluding a non-citizen from the country can burden the constitutional rights of citizens who seek his presence. Acknowledging the government's power over admission and exclusion, the Mandel Court held that a facially legitimate and bona fide reason for the exclusion sufficed to justify that burden. In this case, after protracted litigation, the government finally explained that it denied Muñoz's husband a visa because of its belief that he had connections to the gang MS-13. Regardless of the validity of that belief, it is a facially legitimate and bona fide reason. Under this court's precedent, that is enough. Instead, the majority today chooses a broad holding on marriage over a narrow one on procedure. It holds that Muñoz's right to marry, live with, and raise children alongside her husband entitles her to nothing when the government excludes him from the country. Despite the majority's assurances 2 terms ago that its eradication of the right of abortion does not undermine in any way other entrenched substantive due process rights, such as the right to marry, the right to reside with relatives, and the rights to make decisions about the education of one's children, the court fails at the first pass. Because to me, there is no question that excluding a citizen's spouse burdens her right to marriage, and that burden requires the government to provide at least a factual basis for its decision. I respectfully dissent. Marriage is not an automatic ticket to a green card. A married citizen non-citizen couple must jump through a series of administrative hoops to apply for the lawful permanent residency that marriage can confer. Non-citizen spouses coming from abroad must apply for a visa to enter the United States. In certain cases, however, the law requires even couples who meet and marry in the United States to send the non-citizen spouse back to his country of origin to do the same thing. In doing so, the couple must take an enormous risk to pursue the stability of lawful immigration status. The risk that when the non-citizen spouse tries to re-enter the United States, he will face unexpected exile. In technical immigration terms, a non-citizen spouse applying for a green card seeks to adjust his immigration status from non-immigrant to that of a person admitted for permanent residence. To do so, the citizen spouse must petition the government on the non-citizen's behalf. The citizen spouse first sends United States Citizenship and Immigration Services to a petition to classify the non-citizen spouse as an immediate relative. Once USCIS approves the petition, a non-citizen spouse who is already in the United States can then apply to adjust his status to lawful permanent resident without leaving the country. For a non-citizen spouse living outside of the U.S., however, USCIS first approves the immediate relative petition, but then sends it to the consulate of the country where the non-citizen spouse lives for processing. A consular officer interviews the non-citizen spouse and makes the final admission decision. Because of idiosyncrasies in our immigration system, not all non-citizen spouses living in the United States can adjust their status with USCIS. Even when a couple meets, marries, and lives in the United States, the non-citizen spouse may instead have to travel back to his country of origin for consular processing if he was never formally inspected and admitted or paroled at the border. A non-citizen who entered without inspection in this way typically cannot adjust his status from within the United States based on an immediate relative petition. Once the citizen spouse submits the petition to USCIS, the non-citizen spouse must return to his country of origin and meet with a consular officer who will then adjudicate his application. Living in the United States after initially having entered without inspection is not unusual. In fact, the government endorses the presence of many of these members of our national community. Recipients under the Deferred Action for Childhood Arrivals (DACA) program, for instance, may have been brought across the border by their parents without inspection. Even though DACA status entitles them to work and live in the country without the immediate threat of removal, it does not change their initial entry designation. As of the end of 2023, there were roughly 530,000 active DACA recipients in the United States. The same is true of approximately 680,000 holders of temporary protected statuses (TPS). who have been designated temporarily unable to return to their home countries because of war, natural disasters, or other extraordinary circumstances. Even when married to a U.S. citizen, DACA recipients and TPS holders are barred from adjusting status within the United States if they entered without inspection. Ironically, the longer the non-citizen spouse has lived in the United States, the more difficult and uncertain the process to adjust to lawful status can become. A non-citizen who initially entered without inspection will accrue unlawful presence, which can bar him from re-entering the country if he leaves. If a non-citizen who has lived in the United States between 6 months and 1 year leaves and tries to re-enter, he will be subject to a 3-year re-entry bar. If he has lived in the United States for more than a year and tries to re-enter, he faces a 10-year ban. This scheme places couples who meet and marry in the United States in a difficult position if the non-citizen spouse entered without inspection. The couple can continue to live with one spouse in a precarious immigration status, or they can seek the stability of permanent residency for the non-citizen spouse but face a potential multi-year exile when he leaves and applies for reentry. Recognizing these difficult choice, USCIS allows a non-citizen spouse to apply for a waiver of inadmissibility for any accrued unlawful presence before departing the United States for his consular interview. To obtain such a waiver, the non-citizen spouse must show that the citizen spouse will suffer extreme hardship if her non-citizen spouse is not admitted. Then, once the non-citizen spouse returns to his country of origin, if a consular officer approves his visa application, he can re-enter free from the inadmissibility bar. Consular officers fall under the State Department, not DHS, which oversees USCIS. Even though DHS officers and consular officers make admission determinations under the same substantive laws, see subsection 1182, in reality, a non-citizen seeking admission via consular processing faces a far higher risk of arbitrary denial with far less opportunity for review than a non-citizen seeking admission from DHS. DHS officers are constrained by a framework of required process that does not apply to consular processing. A non-citizen denied adjustment of status in the United States must receive notice and the reasons for the denial. He can renew his application in removal proceedings before an immigration court, where DHS must present any evidence against him in adversarial proceedings. From those removal proceedings, a non-citizen can petition for review to the Board of Immigration Appeals and ultimately a federal court of appeals. In contrast, a non-citizen denied admission via consular processing is entitled to nothing more than a cite to the statute under which the consular officer decided to exclude him. He had no opportunity for administrative or judicial review and can only submit more evidence and request reconsideration. Former consular officers tell this court that this lack of accountability, coupled with deficient information and inconsistent training, means decisions often rely on stereotypes or tropes, even bias or bad faith. Visa applicants may experience disparate outcomes based on nothing more than the luck or misfortune of which diplomatic post and consular officer they happen to be assigned. The State Department's Office of the Inspector General has documented numerous deficiencies in consular processing across several continents. Supervisors are required by the State Department to review a certain percentage of visa denials, but often fail to do so. When the government requires one spouse to leave the country to apply for immigration status based on his marriage, it therefore asks him to give up the process he would receive in the United States and subject himself to the black box of consular processing. Muñoz, a celebrated workers' rights lawyer from Los Angeles, California, met Luis Asensio Cordero in 2008, 3 years after he arrived in the United States. They have been married since 2010 and have a child together. In 2013, Muñoz filed an immediate relative petition for her husband, which USCIS approved. Because Asensio Cordero had originally entered the United States without inspection, the government required him to return to El Salvador, his country of origin, for consular processing to obtain his immigrant visa. Yet he also faced a bar to re-entry if he left the country. DHS granted him a waiver of this bar upon his anticipated return to the United States because of the extreme hardship Muñoz would suffer if he were excluded. In April 2015, Asensio Cordero traveled from California to El Salvador. That was the last time he stood on American soil. Asensio Cordero attended the initial consular interview in San Salvador on May 28, 2015. In December 2015, a consular officer denied his visa application. As justification, the denial cited only to Section 1182A3A2. That statute provides that any non-citizen who a consular officer knows or has reasonable grounds to believe seeks to enter the United States to engage solely, principally, or incidentally in any other unlawful activity is inadmissible. In other words, the consular officer excluded Asensio Cordero based on a belief that he planned to engage in some unspecified unlawful conduct upon return to the United States. Unlawful activity could mean anything from jaywalking to murder. Asensio Cordero has no criminal history in the United States or El Salvador. With no obvious justification for the consular officer's belief, Muñoz and Asensio Cordero asked for reconsideration. Muñoz sought the help of Congresswoman Judy Chu, who sent a letter to the State Department on Muñoz's behalf. The following day, the consulate responded to the letter again with only a citation to subsection 1182A3A2. In January and April 2016, Muñoz asked the State Department for the factual basis for her husband's inadmissibility. She and her husband provided evidence of her accolades at work and attestations of Asensio Cordero's good moral character. A few days later, the consulate notified Muñoz that the State Department had reviewed the denial and concurred with the consular officer's decision. It denied reconsideration. After the consulate denied reconsideration, Muñoz and her husband wrote to the State Department again requesting a factual basis for the inadmissibility decision. Asensio Cordero had no criminal record, but he does have several tattoos from his teenage years. They depict a range of subjects including Our Lady of Guadalupe, Sigmund Freud, a tribal pattern with a paw print, and theatrical masks with dice and cards. Some of these images have deep significance in Latin American culture. Some also happen to appear on gang members. Speculating about potential bases for a visa denial, Muñoz and her husband included additional evidence from a court-approved gang expert in their letter to the State Department. The expert reviewed Asensio Cordero's tattoos and concluded that none were related to any gang or criminal organization in the United States or elsewhere. The State Department responded that it lacked authority to overturn consular decisions and concurred in the finding of ineligibility. The consulate followed up in May 2016, a year after Asensio Cordero's initial interview, by listing all the entries that had reviewed the visa application and noting that there is no appeal. It was only after Muñoz and her husband sued the government in federal district court that they finally received the factual basis for the denial. After almost 2 years of litigation, the government submitted a declaration from the State Department attorney advisor. That declaration stated that the consular officer denied Asensio Cordero's visa application under subsection 1182A3A2 because based on the in-person interview, a criminal review of Mr. Asensio Cordero, and a review of Mr. Asensio Cordero's tattoos, the consular officer determined that Mr. Asensio Cordero was a member of a known criminal organization, specifically MS-13. The Court of Appeals ruled in Muñoz's favor. It held that the government's reason was too little too late. The denial of her husband's visa burdened Muñoz's right to marriage, and the government had provided inadequate process. Even though the government provided a facially legitimate and bona fide reason, that reason was not timely enough to satisfy constitutional due process requirements. This court granted the government's petition for a writ of certiorari. There was a simple way to resolve this case. I agree with Justice Gorsuch that the United States has now revealed the factual basis for its decision to deny Muñoz's husband a visa, and she has thus received whatever process she was due. That could and should have been the end of it. Instead, the majority swings for the fences. It seizes on the government's invitation to abrogate the right to marriage in the immigration context and sharply limits this court's long-standing precedent. Munoz has a constitutionally protected interest in her husband's visa application because its denial burdened her right to marriage. She petitioned USCIS to recognize their marriage so that her husband could remain lawfully beside her and their child in the United States. It was the extreme hardship Munoz faced from her husband's exclusion that formed the basis for USCIS's waiver of his inadmissibility. For the majority, however, once Munoz's husband left the country in reliance on those approvals, their marriage ceased to matter. Suddenly, the government owed her no explanation at all. The constitutional right to marriage is not so flimsy. The government cannot banish a U.S. citizen's spouse and give only a bare statutory citation as an excuse. By denying Muñoz the right to a factual basis for her husband's exclusion, the majority departs from long-standing precedent and gravely undervalues the right to marriage in the immigration context. The constitutional right to marriage has deep roots. Marriage, this court said over a century ago, is something more than a mere contract. It is the most important relation in life and the foundation of the family. This court has described it in one breath as the right to marry, establish a home, and bring up children. A right long recognized at common law as essential to the orderly pursuit of happiness by free men. In upholding the right of Mildred and Richard Loving to have their marriage license from the District of Columbia recognized by Virginia, this court emphasized that marriage is one of the basic civil rights of man, fundamental to our very existence and survival. Indeed, the right to marriage was one of the first building blocks of substantive due process. The right was so fundamental and implicit in the concept of ordered liberty that the Roe Court invoked it as part of the foundation underlying the right to abortion. Almost 10 years ago, this court vindicated the expansiveness of the right to marriage. It upheld the right of James Obergefell and his terminally ill husband, John Arthur, to have their marriage from Maryland recognized in Ohio. Rejecting the idea that Ohio can erase Obergefell's marriage to John Arthur for all time by declining to place Obergefell as the surviving spouse on Arthur's death certificate, this court reasoned that marriage is a right older than the Bill of Rights. Marriage fulfills yearnings for security, safe haven, and connection that express our common humanity. Marriage responds to the universal fear that a lonely person might call out only to find no one there. It offers the hope of companionship and understanding and assurance that while both still live, there will be someone to care for the other. The majority, ignoring these precedents, makes the same fatal error it made in Dobbs, requiring too careful a description of the asserted fundamental liberty interest. The majority faults Muñoz's invocation of a fundamental right to marriage as difficult to pin down. Instead, it tries to characterize her asserted right as an entitlement to bring her husband to the United States, even though it acknowledges that Muñoz disclaims that characterization. Obergefell rejected what the majority does today as inconsistent with the approach this court has used in discussing the fundamental rights of marriage and intimacy. Cataloging a half-century of precedent on the right to marriage, the court stressing that Loving did not ask about a right to interracial marriage, did not ask about a right of inmates to marry, and did not ask about a right of fathers with unpaid child support duties to marry. Instead, each case inquired about the right to marry in its comprehensive sense of marriage and intimacy. Similarly, Muñoz does not argue that her marriage gives her the right to immigrate her husband. She instead advances the reasonable position that blocking her from living with her husband in the United States burdens her right to marry, establish a home, and bring up children with him. This court has never required that plaintiffs be fully prevented from exercising their right to marriage before invoking it. Instead, the question is whether a challenged government action burdens the right. For example, the court in Zablocki v. Redhale re-examined the burden placed on fathers by a statute that required a hearing to counsel them as to the necessity of fulfilling any outstanding child support obligations before being granted permission to marry. The court in Turner v. Safley applied Zablocki to incarcerated people to hold that the particular prison marriage restriction at issue impermissibly burdened the right to marry. There can be no real question that excluding a citizen spouse from the country burdens the citizen's right to marriage as this court has repeatedly defined it. This court has never held that a married couple's ability to move their home elsewhere removes the burden on their constitutional rights. It did not tell Richard and Mildred Loving to stay in the District of Columbia or James Obergefell and John Arthur to stay in Maryland. It upheld their ability to exercise their right to marriage wherever they sought to make their home. Muñoz may be able to live in El Salvador alongside her husband, or at least visit him there, but not everyone is so lucky. The majority's holding will also extend to those couples who, like the Lovings and the Obergefells, depend on American law for their marriage's validity. Same-sex couples may be forced to relocate to countries that do not recognize same-sex marriage, or even those that criminalize homosexuality. American husbands may be unable to follow their wives abroad if their wives' countries of origin do not recognize derivative immigration status from women. The majority's failure to respect the right to marriage in this country consigns U.S. citizens to rely on the fickle grace of other countries' immigration laws to vindicate one of the basic civil rights of men and live alongside their spouses. Given that the government has burdened Muñoz's right to marriage by excluding her husband from the country, the question is the remedy for that burden. Muñoz argues that this burden triggers procedural due process protections in her husband's visa denial, emphasizing that substantive due process rights, like the right to marriage, usually trigger strict scrutiny. The majority faults Muñoz for creating a right in a category of one, a substantive due process right that gets only procedural due process protection. Muñoz, however, did not create that category of rights. This court did. This court already set the ground rules for when the government's exercise of its extensive power over the exclusion of non-citizens burdens a U.S. citizen's constitutional rights. In short, a fundamental right may trigger procedural due process protections over a non-citizen's exclusion, but such protections are limited. Non-citizens who apply for visas from outside the United States have no constitutional entitlement to enter the country and therefore typically have no constitutional process protections in the visa application themselves. In contrast, non-citizens who already live in the United States, whom the government seeks to remove, have procedural due process protections during that removal. Had the government sought to remove Muñoz's husband when they were living together in the United States, he would have had his own constitutional protections in those proceedings. Instead, because the government forced him to leave the country and re-enter in order to adjust his immigration status, he lost them. Not only do non-citizens seeking to enter the United States lack constitutional process rights in their visa applications, this court has further insulated the government's visa determinations from review by declining to evaluate them at all. This judge-made doctrine of consular non-reviewability reflects the judicial branch's recognition that the admission and exclusion of foreign nationals is an area of unusually heightened congressional and executive power. When the denial of a non-citizen's visa burdens a U.S. citizen's constitutional rights, however, this court has had to reconcile the importance of those rights with its recognition of government authority over visa determinations. In Mandel, it set the remedy. The Mandel court held that when a visa denial implicates a citizen's rights, a court will not look behind a facially legitimate and bona fide reason for the denial. In Mandel, a group of U.S. professors sued the government over the visa denial of Dr. Ernest E. Mandel, a famous Belgian Marxist. The professors argued that excluding Mandel burdened their First Amendment right to hear and meet with him in person. The court agreed that the professors had a First Amendment right to receive information from Mandel. It also emphasized, as the majority does today, Congress's power over the admission and exclusion of non-citizens. To avoid the need to balance the strength of the audience's interest against that of the government in refusing a waiver to the particular non-citizen applicant, according to some as yet undetermined standard, the court instead noted that the Attorney General did inform Mandel's counsel of the reason for refusing him a waiver, and that reason was facially legitimate and bona fide. Therefore, when an executive exercises conditional power to exclude negatively on the basis of a facially legitimate and bona fide reason, the court will neither look behind the exercise of that discretion nor test it by balancing its justification against the First Amendment interests of those who seek personal communication with the applicant. In other words, when a visa denial burdens a non-citizen's constitutional rights, rather than attempt to balance the competing interests under strict scrutiny, A court should accept the government's facially legitimate and bona fide reason. That minimal requirement ensures that courts do not unduly intrude on the government's sovereign authority to set the terms governing the admission and exclusion of non-citizens, while also ensuring that the government does not arbitrarily burden citizens' constitutional rights. This court has repeatedly relied on Mandel's test in the immigration context. Indeed, less than a decade ago, 6 justices ruling on the exact legal question the court confronts today would have held that Mandel controlled or extended its protections even further in the marriage context. Outside the immigration context, this court has endorsed similar tests in circumstances where there is a heightened underlying governmental power. For instance, in Turner, the court evaluated the right to marriage in the prison context. Even though an incarcerated person retains those constitutional rights that are not inconsistent with his status as a prisoner or with the legitimate penological objectives of the correction system, the court emphasized that the right to marry, like many other rights, is subject to substantial restrictions as a result of incarceration, only because the challenged prison regulation there was not reasonably related to the government articulated penological interests or legitimate security and rehabilitation concerns, did this court hold it unconstitutional. Justice Turner looked at burdens on the right to marriage through the narrow lens of penological interests to defer to the government's control over prisons. Mandel used a facially legitimate and bona fide reason to defer to the government's power over the exclusion of non-citizens. Neither case erased the constitutional right at issue. The court simply recognized that the right can be substantially limited in areas where the government exercises unusually heightened control. Applying Mandel and Turner here, the remedy is clear. The government's exclusion of Muñoz's husband entitles her at least to the remedy required in Mandel, a facially legitimate and bona fide reason for the exclusion. The majority resists this conclusion by worrying about its unsallying collateral consequences. The majority poses a series of hypotheticals that it fears will result from recognizing the limited right Muñoz proposes. These fears are groundless. First, the majority is concerned that applying Mandel to Muñoz's right to marriage in this case will result in a slippery slope of constitutional challenges is unfounded. Muñoz's right triggers limited process protections in part because her husband lost his own procedural protections when the government required him to leave the country. Muñoz's right to marry raised that floor from zero process to some by requiring the government to provide a facially legitimate and bona fide reason when her husband receives no process. In contrast, a citizen's liberty interest in the removal proceeding of her spouse in the United States would presumably be limited by the non-citizen's own due process rights in that same proceeding. Similarly, any challenge from a wife to her husband's assignment to a remote prison would presumably be limited by the criminal procedural protections her husband already received. Second, the majority's reliance on O'Bannon v. Town Court Nursing Center is misplaced and highlights the speculative nature of its concerns. O'Bannon rejected a freestanding constitutional interest in avoiding serious trauma. The residents of a government-funded nursing home sought relief from transfer to alternative housing because of the emotional harm they would suffer from the move. Muñoz, however, does not rely on a free-floating emotional harm that separation from her husband will cause. She invokes her fundamental right to marry, live, and raise a family with her husband, the right recognized by this court for centuries. Denying her husband entry to the country directly burdens that right. In sum, the majority's concerns are unwarranted. There are few circumstances where the limited relief sought by Muñoz would be available. A facially legitimate and bona fide reason may seem like a meager remedy for burdening a fundamental right. Yet even the barest explanation requirement can be powerful. The majority relies heavily on United States ex rel. Knopf v. Shaughnessy. A closer look at the story of Ellen Knopf, however, illustrates the importance of putting the government to a minimal evidence requirement when a visa denial burdens a constitutional right. Knopf's U.S. citizen husband sought to bring her to the United States after they married during his deployment to Germany. After this court upheld her exclusion on undisclosed national security grounds, there was a public outcry. Both houses of Congress introduced private bills for her relief, and after the Attorney General rushed to remove Knopf from Ellis Island before Congress could act, Justice Jackson, who had vigorously dissented in the case, issued a stay from this court. After extensive advocacy, the Attorney General ordered immigration officials to reopen the case. Eventually, Knopf won her case before the BIA when the government failed to prove up its national security concerns. She was finally admitted as a lawful permanent resident. The majority relies heavily on the rule of Knopf, that the Attorney General has the unchallengeable power to exclude a non-citizen. Yet the full story of Ellen Knopf shows a populace and a Congress unwilling to accept the exercise of this sort of raw power. Once the government was required to justify its exclusion decision with substantial and reliable evidence in an open proceeding, Knopf gained admission into the United States. Knopf brought her own habeas petition to challenge her exclusion. Her husband did not argue that her exclusion burdened his right to marriage. 22 years after Knopf, however, when faced with such a challenge, this court limited the justification that the government must provide in these circumstances to a facially legitimate and bona fide reason. The majority, not content to resolve this case on even those narrow grounds, instead relieves the government of any need to justify itself at all. Knopf's story illustrates why the right to marriage deserves more. By leaving U.S. citizens without even a factual basis for their spouse's exclusion, the majority paves the way for arbitrary denials of a right this court has repeatedly held among the most important to our nation. A traveler to the United States 2 centuries ago reported that there is certainly no country in the world where the tie of marriage is so much respected as in America. Today, the majority fails to live up to that centuries-old promise. Muñoz may be able to live with her husband in El Salvador, but it will mean raising her U.S. citizen child outside the United States. Others will be less fortunate. The burden will fall most heavily on same-sex couples and others who lack the ability, for legal or financial reasons, to make a home in the non-citizen spouse's country of origin. For those couples, this court's vision of marriage as the assurance that while both still live, there will be someone to care for the other rings hollow. I respectfully dissent. Well, that was a good read, and as usual, if there's any case you'd like me to read, just drop in the comments and I'd be happy to take a look. Thank you.